Hello, my friends. Welcome back to Breakfast with Sergio. We are here again with Jaime Guzmán, who is an attorney at law here in Chicago, who he's helping us breaking down the copyright law in easy to understand terms for us here at Breakfast with Sergio, friends. Super happy to have you back again, Jaime.
Hey, good morning. Thank you again for having me.
Of course. And we are on a series where we are, breaking down the law. And today we're going to talk about, can I borrow from other art? A typical case of appropriation where as artists sometimes, we are inspired by something externally. Let's say you get a magazine, a newspaper, you want to cut something out, stick it in your artwork. That's an example. Or, now it's so easy with the web. You go and you search for something you maybe want to make. And you use that photograph who came from who knows where, and you use it as, to copy it for your art. There's so many ways in which artists are using images. So, Jaime, if you can help us kind of break that down a little bit and tell us, can I borrow art from other sources?
Absolutely. So this falls into the category of what are known as derivative works, right?
Okay.
And derivative works, for the most part, what they are is they're things that are created that are inspired by other things, right? Other pieces of art, other works. And what they end up doing is they end up taking just enough of it to then create something new, and then that new thing is copyrightable, and it's copyright protected. Okay. Why? If you recall from our first episode, the Constitution does not want to stifle innovation and creation.
Right.
We want to make sure that we have a system that protects original art pieces of art, but at the same time allows other people to create newer pieces of art, even if they're inspired by those original pieces of work, right? So what ends up happening a lot is artists get inspired by different things, right? And sometimes those things are other pieces of art and other works, and there's sort of a line that we can't cross, though. Right? There's only so much we can borrow and so much we can take before we're infringing on the original piece of art. Okay. There's a few sort of guidelines as to how to approach this, and one of the things is, if you're creating a derivative work, you want to make sure that it's definitely distinguishable from the thing you're borrowing from, right? And why is that important? It's important because if you created a derivative work and you're accused of infringement, one of the things that the court's going to look at is, well, are you taking from the sort of total concept and feel of the original work? What does that mean? That means, are you grabbing from the heart and soul of the artwork, right? Are you tapping into what it is that makes it attractive, right? And so if you're borrowing from the main part of it that people are gravitating towards, and that's the reason why they recognize that original work, you're very likely going in a direction where you're committing an infringement. Okay? What you want to do is borrow just enough to sort of create a whole new thing that within itself creates its own identity. And you're not necessarily trying to borrow or take the identity from the original piece of work, right? There's been,
and I'm sure sometimes there might be a gray line to. I mean, it's not a hard line that,
right.
From now on, now you are or you are not. I assume there are
because
gray areas.
That's right, and it varies by medium. It varies on the approach, right? One of the examples that we have for this sort of thing is that there was a photographer that took a picture of a basketball player, a professional basketball player, and what he did was he eventually sold it to a magazine, right? And so the magazine paid him some money to be able to use the photograph. And what they did was they put it out in a full page spread. But then what ended up happening a couple of years later is that he was driving down the road and he looked up and he saw a beer billboard sign, right?
Uh-huh.
And what it was is it was a portion of the photograph that he took of the basketball player. The picture of the basketball player, the original one, was from his head
Uh-huh.
to about mid thigh.
Okay.
And what he saw in the billboard, though, was a picture of the basketball player's neck to mid thigh, so you couldn't see
Okay.
the face
His
anymore.
face. But he recognized the body.
Right, but he recognized the body because the basketball player was wearing very specific white clothes, but also very specific jewelry he had on.
Ah, okay.
Right, it was very distinguishable, the jewelry.
Mm-hmm.
And so he looks up and he goes, why is my picture up there and nobody asked me for permission, right, to be able to
Mm-hmm.
use this? Because what he did is he didn't sell the picture to the magazine, right?
Yeah.
He gave them a license to be able to use the picture, so they paid him some money to be able to do it, right?
Mm-hmm. Mm-hmm.
And so he's like, what can I do about this?
Yeah.
So he sues, right? And he goes through this process of trying to get his money because they owe him something for using it without his permission. That's reasonable to think.
Mm-hmm.
What ends up happening is the court decides that there are certain instances, because we don't want to stifle creativity,
Mm-hmm.
that you should be able to borrow things. You should be able to take some of that to create something totally new.
Mm-hmm.
Okay? And in that case, because he had the beer company had taken just a portion of the picture, even though it was a big piece of the picture,
Uh-huh.
and I mean a big piece. The only thing they left out
head.
was the head, and the fact that they had converted it into a black and white image as opposed to the color image that he originally put out.
Mm-hmm.
And that's because they superimposed in color the beer and the logo, and to show the contrast. I mean,
Right.
marketing people do that sort of thing.
Yeah. And
so he ended up losing that case, but that gave us the lesson of how much can you take, and that's because it depends on what it is that you're using it for and how much of it. In that case, the court decided that, well, he's borrowing a lot, but it's not borrowing enough to really take away from the original piece. One, because you can't identify the original. You can't identify the original model, right? Because the basketball player's head isn't there. There's a lot that was done to modify the image in terms of the black and white, and then in terms of the way it was sort of laid out for the design of the billboard. And because of that, that artist wasn't able to recover on that. But that just goes to show how far these things can go. And then that becomes its own copyright protected work. Because even advertisements are copyright protected. That was a lesson that here in this country we learned back in the late 1800s. Back in the late 1800s, before most people were using printing presses, and there was things that were sort of hand painted and that sort of thing. Even though there was people that were already doing a press, but there was people that were still hand painting advertisements. And to be fair, people still do it today.
Right.
You still see it at supermarkets that people are still hand painting the numbers and that sort of thing,
Right.
But back then there was this case about a circus announcement, right? And the circus, the guy that designed the circus announcement had an issue with the printer. The printer that was originally hired to print the posters and the advertisements took it upon himself to print more copies and sell them, because it was a lovely piece of work. It wasn't just an advertisement. It was a beautiful piece of work that showed the trapeze artist and the different types of characters in the circus. And so in that case, the artist did sue and won, right? But again, this thing about derivative works, it really does depend on how much you're taking. One needs to be very careful on how much they're borrowing, because you never know, especially when it comes to other mediums. I think in a photograph, you can borrow a little more because there's less that's sort of original about it. although our understanding of originality comes from the fact that there was once a picture taken of a subject, and the photographer, as long as they told the subject what to wear, how to pose, how to sit, where to sit, and that sort of thing, there was that was part of the assessment of whether it was original, right?
Right, right. And I
So
think the
there's
next episode we're gonna talk about
yeah,
what is copyrightable. Yeah.
yeah. So it's that kind of thing, right? But at the end of the day, um, other mediums, especially
Hmm.
painting and some of these other things, the more you borrow, the more careful you should be treading, because the reality is those things, you can really delve into an analysis of whether or not you're grabbing into the heart and soul of the work. And if you
Right.
are, you're likely going to be infringing on it. And then you're going to run into these issues where you're going to have a good defense
Yeah.
for an infringement, which we'll talk about later on.
Awesome. Well, this is a really interesting topic, and I'm sure we can keep talking about this one for quite a bit. But I think that you have given us some grounds for consideration, for ideas. As you, my artist friends, as you are working in your production, things to keep in mind, especially now, because we have the internet, so things just fly everywhere, right? Things just go in an instant. They can be seen, can be borrowed, can be shared so fast, and it's so easy. You can't hide anymore from the world, right? Because everybody can see what you're doing.
Exactly, exactly.
Yeah.
And there was a time
Uh-huh.
where judges were the ones that were deciding whether something was taking from the heart and soul of things. And then,
Yeah.
thankfully, over the decades, art proponents were like, wait, what is it about you being a judge that
That's
qualifies
it.
you to say this is something that's been
Thank
taken,
you.
how much has been taken, right?
Right.
And so what they've done is they went from, judges like to take this approach called the ordinary person standard.
Okay.
And so to them, they believe they can put themselves in the mindset of the ordinary person,
That's it. Mhm.
and say, okay, this is what the ordinary person would see. They would see that there's so much similarity, you borrow too much. Okay. Well, luckily nowadays they bring in experts. They bring in people in the art
Yeah.
world that can say, okay, they'll assess it based off technique, based off means,
Oh,
based off
good.
a medium. This
Mhm.
is the difference between the two. And it's
Yeah.
very likely that they did infringe or they didn't infringe. So thankfully that's where we're at. That people that we finally value people like you, Sergio, that have been in this, understand it,
Yeah.
know art, know the artist community, and that can
Yeah.
give us an objective opinion about where the art stands in comparison to one another.
Awesome. Well, thanks so much, Jaime. I think once again, you have given us some great insight, breaking the law down to understandable terms for all of us. Thank you so much for your time, Jaime. I know you're a busy man, and I know you got things to do, and keep working, keep chopping at the law.
It's my
So,
pleasure. My pleasure. Thank you.
thank Jaime. So, my friends, don't miss the next episode where we're gonna talk about what is copyright protectable? What is protectable? And so, what can I protect under copyright law? So, don't miss that episode. It's gonna be awesome. Jaime again is gonna help us out with that. And please share this episode with your friends. That's one way in which you can help Jaime and I to be so happy today. If we see a lot of shares and you're sharing with your friends, tell other artists about it as well. So you know that we can all be informed and prepared as we go in our art career. Thanks so much, Jaime. Until the next time, we'll see
Thank
you
you.
later.